afternoon and welcome to the second residential conveyancing forum for Scotland for 2025. Pleased again to be joined by Ian Quayle, who'll be leading us.
I'm all right. I thought you said there, Robert, he'd be leaving us. I'm thinking, crikey, have I been sacked?
Yes,
Yeah, I'm very well, Robert. Very well indeed. The sun is shining up north today, and very pleasant. But I think everyone is really, really busy at the moment. It's crazy, isn't it?
I think down here in England and Wales, the stamp duty deadline, that's affecting it. But I think generally mortgage rates and so on, people do seem to be getting out. And we, I was just saying, we had our busiest month ever online for inquiries in February. Yeah. So, and that goes right back to 2016. So, yeah, it does show there's something happening out there.
Yeah.
Hopefully it will convert into completions for all of us and make some money out of it.
Absolutely.
But also with that pressure of work means we need to work more efficiently. So very pleased that we're joined today by Tom Bailey from Post Partner, who'll be explaining some of the ways that he and his team and technology can help you free up fee earner time for the important stuff and to sort out the admin in a more appropriate way. Even though we're not paper-based as conveyancers anymore, it's still document heavy. So actually being able to get the documents into the right file so you can look at them is important. And I know Tom will be talking about that. So if I hand over to you, Ian, to talk to Tom and then to get on to today's topics, that would be great.
Fantastic. Yeah, lovely. Thanks very much. A massive thank you to Stewart Title for inviting me along today and for inviting Tom along today. Robert and the team at Stewart Title, John and Liz, are really, really nice people to work with and deal with. Again, I was with Robert last Thursday talking about lots of different things and the team from Canada. And they are really, really supportive of the Scottish legal profession. They have a vast array of product available for you. And John, Liz and the team at Stewart Title are willing to listen if there are gaps in the market or products that you would like Stewart Title to be able to offer. You know, subject to the viability of product. I know that Stewart Title and their underwriting team and their base in Canada and the US are keen to sort of develop connections and to develop opportunities for all concerned. So there is online policies and cover available. There are bespoke policies and cover available. And of course, Stewart Title sponsor events such as this. So do speak to John or Liz or Robert about your needs and requirements. So contact details are on slide there for you. But before we go any further with regard to topics, and I'll just mention before I introduce Tom, the purpose of today, if you have any burning issues or topics, type them into chat whilst Tom is talking, and we'll look at them before we finish. I've got a whole raft of things that I would like to explore, but before I do that, Tom, it is lovely to see you. Once again, I think your Christmas song, did it make number one, or was it knocked off by one of those nasty politicians? I don't know. It was a bit of a blur, but it was a good song, I can tell you that for nothing. So fantastic to see you, Tom. Fantastic for you to share your skill, experience, and your fantastic product with regard to Post Partner. So, Tom, I will push the slides along, and over to you for a while.
Yeah, thanks, Ian, and thanks, Robert, and everyone at Stewart Title as well for having me along today. Appreciate it. It's very kind. For the attendees who probably mainly don't know me, I'm the managing director at Post Partner. We, as it says on the slide there, we sort of help law firms to manage their inbound documents and data, actually, not just the documents, but the data on them in a variety of ways. And I think what's becoming clearer to me, and is when I attend events, every firm in different ways, but everyone we speak to is trying to make efficiencies, or putting it even in simpler than that, they're trying to tidy up when it comes to their inbound documents, which across email, physical posts, and also documents coming in through portals, so through those three channels, can be quite overwhelming, because whether you're a very big firm or you're a high street firm or a sole practitioner, to scale, there's a lot of stuff coming in. So yeah, that's what our products sort of set out to try and help with. I was at the Conveyancing Association annual conference a couple of months ago now, and to show the kind of range, we had inquiries from people who were saying, look, we've got physical documents piling up here, Tom, can you help give us some software to help us get it in the system, all the way through to a firm we've got quite a sizable team out in India who are getting 500,000 emails in a month, and then they're doing data entry. Is there something you can do to help us with that? So there's lots of different flavors of this, but I think ultimately the takeaway message is people struggle with the sheer volume of inbound stuff, and what we're trying to do is help them with that, get it to where they want it to be, ideally with the correct name on it, and then the most sophisticated end, our product Data Collate can actually lift specific data items off the documents at the same time and move them, and that reduces the admin that Robert, you mentioned earlier on, the admin of fear and having to sort of type in details off a mortgage offer. Well, we can train our software to do that, so it does it for you and enables people to do higher value tasks. So that's kind of an overview, Ian, if that's helpful.
Yeah, fantastic, Tom. No, that's great. Really useful. So this idea of automation, Tom, can you just explain, you mentioned your sort of client base and your breadth of sort of client is quite extensive. As far as your journey is concerned and the business is concerned, where do you see it going? Do you see it being more and more sort of data management rather than document management, or do you see it as 50-50? Just interested in your views on that.
Yeah, so I think physical posting, I think will reduce over time.
Right. Yeah.
And that that'll be linked into some of the stuff that they're doing in other organisations like the Land Registry and so on. You can't get rid of certain documents until those processes have changed, but it will ultimately reduce. I think it's already started reducing, and it will go down further. I don't see email reducing, frankly, right. and I don't see documents coming in through portals reducing. All the same documents that were ever in the process still need to come through. They should come through in a different way. Yeah. So I think our original product of allocating and indexing, so moving the documents with the correct name on, will probably shift more from physical post to email and to portal stuff. But the direction of travel ultimately, and we're well placed for this now, is people don't just necessarily want the document. They would go, well, of that 20-page mortgage offer from Santander, what I really want, Tom, is I want 15 data items off it. Yeah. So I think the 20-year plan for my business, I think, is how can we really help with the data management. But there's still a lot of email. There'll be people on today's webinar who'll be thinking, my biggest problem is I get too many bloody emails, frankly. And when the attachments come in, they've got stupid names on them. It's called 2025-1803.xerox, and I need it to be called mortgage deed. That kind of thing. So there's plenty of tidying up to be done, but in the long term, I think it's about data management. Rather than document management, I think. Yeah.
So Tom, the next question: assume I'm a lawyer in Inverness, right? And assume that I've listened to what you've had to say today and thought, there's documents coming in that we need managing. There's data that's coming in that we need managing. As far as your service is concerned, can it be done remotely? Is it necessary for you to go and see the client in Inverness to sort of assess their needs? Or what are the mechanics of you onboarding a firm? How does that work?
Well, this, like many businesses, I suppose, COVID changed everything for us. We used to always go physically on site and sit there and click all the buttons. But now as long as people are savvy, to answer your question directly, Ian, as long as people are happy for us to support them remotely versus through Teams or through Team Viewer, those kind of technologies, that actually saves them a lot of money, because it saves us money. We don't have to travel to Inverness in your example, and 100% we can set a firm up remotely, and then it's understand, first and foremost, understanding where that firm is on their journey. For them, for one firm, it might be, Well, at the moment, we don't even scan the post. We need to sort that out. We need to get it on the system because we're not more reliant on the system now. For another firm, they might go, well, we sorted that out 5 years ago. But what we are struggling with is we're struggling with getting, we've just got too many emails and we struggle to get them into the system. And then for, there'll be firms maybe you think that they've got that cracked as well. And they're thinking, well, actually, I like the sound of this data collate thing. So what we're saying there is, as the document comes in, you're not just moving it to the right place, you're extracting the data and moving that to fields within the case management system. Well, that'll save our team loads of time. So understanding where they are on the journey, but all of that can be done remotely, and a lot of it can be done hand in hand as well. So what we find sometimes is people are interested in, let's say they're interested in the data collate thing initially, then they realise, actually, we're not doing a terrific job of indexing and our post. It's not always named correctly. So can you help us with that? And then we can start do that way around, or the other way around. We start with the indexing and post, and then add on the data collate later.
Got you. And then lastly, Tom, the thorny issue of cost. I guess it's you price the job depending on what the job is, given the spectrum of what could be entailed. So again, you can do that relatively easily once you've seen what the task is. What's the mechanics of that?
Yeah, well, we can sort of flex to suit the firm. We're a realistic business, small business, realistic business. But when people are dealing with the commercials of it, they're dealing with me, and I want to make it work, obviously.
Yeah.
So we can do it. We can sort of, based on estimated volumes of inbound documentation or inbound data items, we can sort of come up with a monthly fee. Yeah. Or if it suits people better, we can also do a per transaction fee where we go, we'll handle 5 different document types for you for data collate. So we'll scrape the data from 5 different documents and we'll come up with a per transaction cost for you, because then when you're busier, you pay more, but when you're less busy, you don't have to pay as much. So we just try and make it work. And, we're not wedded to any, unlike a big, a really big, IT company, we're not wedded to particular things. We've got guidelines, of course, but we can be flexible, Ian. Yeah.
Brilliant. All right. Thanks for that, Tom. Tom, that was absolutely fantastic. So we've covered optimum post room, have we, or not? We haven't.
Yeah. So that's the general. I'll just flick through these quickly. The post room is the scanning stuff. So that's what we've been doing for many years. If you flick onto the next one, that's where we're helping firms to move their emails and the email attachments. So that second example I gave at the Conveyancing Association, they are dealing with hundreds of thousands of emails a month. They're currently taking many people to do it. So we're starting to automate that for them. Not all the time, can't automate everything, but we can certainly strip that back a lot so that the fee earners are just coming to it and it's in the system already. They use visual files, but it's already in there for them. So that's e-filer. And the next slide is data collate. I've mentioned a couple of times. So a good example for conveyances on the webinar is you get a mortgage offer in. It's 20 pages. It's from Santander or it's from NatWest, Bank of Ireland, whoever it is. And you don't need to read all of that information. Ideally, you just want 15 bits of data. We can just run that through our system and train it to pull out the bits and pieces you want and move that to wherever you want it to be. So that's data collate. So that's the most sophisticated end.
Yeah. So with regard to that, then I can tell you that in that type of document, this is what I want you to scrape, and you bespoke it so that and I can then put that into whatever template I wish or whatever report I wish or anything. Yes, I'll get you right.
Exactly. And lots of firms, what they're looking to do is, if they've got a case management system, they want, at the moment, somebody might be typing in, right, the mortgage offer expires on the 18th of March. Well, we can tell the system to go and get that piece of data and put it straight in the field. So it's reducing the amount of manual data entry.
Yes.
But it's that's a great time saver, obviously, and it saves money. But it also cuts down on mistakes, Ian, because we can build confidence thresholds around these things and make sure that unless we're at the confidence threshold we're comfortable with, it's just going to say, well, on this occasion I couldn't find that piece of data. In which case it moves back to a manual process. But the hit rates are extremely high. So most of the time, the data you're after is going straight into the system. It's going in. Systems are very, very good at certain things, and they're not so good at other things. But what they are very good at doing is doing consistency. So it's not going to, you might have 3 different people if they're doing it manually, they might enter it 3 different ways. Yeah. Well, the system enters it the same way every time. So you get that consistency. So it's good for management information as well.
Yeah, brilliant. Okay, thank you, Tom. And then your details on there, that's the correct contact details.
That's it. That's my personal mobile number, and I'm happy for people to contact me there. But obviously, the info at Post Partner will channel its way through to me as well.
Yeah, brilliant. All right, Tom. Well, listen, as ever, lovely to see you. Lovely to speak with you. Keep in contact. If we get any enquiries, etc., we'll push them on. And as and when you've got new product or anything else that's innovative that you want to discuss, come along, Tom, because it'd be brilliant to see you, and great for delegates to hear about what you're doing. Really appreciate your time today.
Thanks so much, Ian. Thank you to
Thanks,
Stewart
Tom.
Title.
Take care.
Take care.
You. Bye-bye. Okay, so what do I want to talk about today? Remember, you're more than welcome to put any topic into the chat box and we'll look at that. But I want to talk about car parking. And first of all, I don't know if you've seen this, a practical law guide to car parking in Great Britain, written by a KC called Ian Mitchell, dual qualified, both Scotland and England. And he's written a book on car parking. And to be honest, he's really focused on car parking in Scotland, and really interesting. So what I wanted to do today was to share with you a case that you may or may not be familiar with, a case called Hamilton against Nairn, 2011 decision. I don't know if you're familiar with it. I'll put it in the chat box. And I just thought it was a really interesting case because quite frequently this sort of issue can arise, and it's nice to see that for once we've got some law that clarifies the position. So anyone familiar with this case? It concerned a property in Aberdeen. Respondents concluded missives to purchase a plot of land next to Coulter House Road in Aberdeen in order to relocate their cattery and livery business and build a new house. They got planning permission from the council for that purpose, and they also got consent from the council to improve the junction of the driveway to the property with the public road. The proposed improvement did involve the cutting across the verge of the road. And what you had here was a reclaimer that had purchased the verge across which the new access was to be formed and sought to prevent the respondents from carrying out the works. So there was a sort of ransom strip position arising. Respondents sought against the reclaimer decrees of declarator and interdict in order to stop the reclaimer from preventing the work. Reclaimer's argument was the public right of way or passage extended only to the metal surface of the road on the basis that it wasn't used for passage of vehicles. Not surprisingly, that argument failed before the court. First, because vehicles did use the verge for passage. Since the road was narrow, vehicles required to use the verge to pass and repass each other. And in any event, because the requirements of Section 151 of the Road Scotland Act is for a right of passage by whatever means, which includes pedestrian use. So the reclaimer's subsidiary argument was that if passage by pedestrians was relevant, nonetheless the road as defined by Section 151 is limited to only those parts of the verge over which pedestrians walked. And the court said that's not right. Case called McRobert against Reed, 1914 case. Such a proposition would appear to be contrary to the views expressed by Lord Skerrington in that case. So again, just an interesting case highlighting the importance of making sure that when we're dealing with roads, that we are comfortable that the extent of a road is not limited to metal surface, but would include grass verges where members of the public have the right to repass. The book's really interesting because it covers parking on roads and highways in Scotland, discusses issues associated with local authority provision for car parking, again, private car parks, and something I was really interested in that I was reading last night, the servitude of parking. So again, published by Law Brief Publishing, written by Ian K. Mitchell, KC, The Law of Parking in Great Britain. Really interesting read. I'm going to try and get Ian to come along to a future forum, because I think there's some interesting stuff that he's got in there that I think would be of real interest to everyone. Again, the next thing that I wanted to talk about was something I don't know whether you've seen. I'm just going to put it up on my other screen, if you bear with me. Land Reform Scotland Bill. Anyone seen that? Really interesting bit of legislation, this, isn't it? Or potential legislation. Applying to large landholdings over 1,000 hectares, prohibiting sales until ministers consider the impact on local community, leads to landholdings being lotted into smaller parts to help local communities. Has anyone looked at this? I was sort of quite taken aback about just how wide-ranging and expansive the powers of ministers would be. This idea about the ministers choosing the size and extent of lots with regard to the sale of large landholdings. I can understand why you'd want to do it, to give local communities a better opportunity to acquire amenity land or other land for the purposes of community. But the idea of having this sort of micro approach with government ministers having control, I think, is quite staggering. The bill also places legal responsibilities on the owners of the very largest landholdings to show how they use their land and how that use contributes to key public policy priorities, such as addressing climate change and protecting and restoring nature. These owners would have to engage with local communities about how they use the land. Duty on the Scottish ministers to publish a model land management tenancy, which will support people to use and manage land in a way that meets their and their nation's needs. Nothing like this in England. Anyone looked at this? Anyone got any comments to make about it? It looks to me as if there's a real appetite for this to become law. And again, I think the spirit of the legislation is good. Rights and responsibilities in relation to land and its natural capital fully recognised and fulfilled. Proposals to allow the benefits and opportunities of Scottish land to be more widely shared. So again, all of that is very welcome. But it's interesting to see just how this is going to manifest itself. So I looked at some of the proposed measures. New power for ministers to require the lotting of large landholdings, as we mentioned, towards a fairer and more dynamic approach to land ownership in Scotland. And again, it looks as if that's going to become law. Anyone got any comments on it? Anyone see how it could impact on the work that they're doing? John, hi John, you've got your hand up. John from Stewart Title, lovely to see you and hear from you. Carry on.
I read a bit about this morning, Ian. It appears that there's quite a number of agencies and others throughout Scotland who require this bill to be substantially amended.
Yeah.
For a whole number of reasons. So, although on the face of it, the initial bill is fairly extensive,
Yes.
who knows, by the time, I believe there's been consultation on it, but
yeah, there has.
It seems to be that it requires quite a bit of amendment further.
Yeah.
And
Well, John, if I was a landowner or a member of the Scottish Landowners Association or whatever, I'd be up in arms about this
so
because it infringes human rights and all manner of things, doesn't it?
Yep.
So yeah, we might see a watered down version, John. You're thinking?
Well, I thought what I read this morning, it seemed to suggest that it wasn't possibly going ahead in its current form,
Right,
and it would be some time before they could do a watered down version.
Yeah. Okay. Right. That's really interesting. Thanks for that, John. The next thing I wanted to talk about was a case that was brought by a firm of surveyors against a client, Elias Smith and Garrett Limited, against Jean Golightly, which was a debt action for £722.40. Nothing startling in that. But the case concerned the production of a report by the company for Miss Golightly, who was a property owner. She put a house up for sale. During the sale process, she became aware of a boundary discrepancy between the extent of the property that was in occupation and what was shown on her title plan. So she instructs the surveyors to investigate and clarify her boundaries. And the surveyors accepted their instructions, sent out terms of engagement, did the work, and sent her an invoice. The work was sent to Miss Golightly, and it confirmed the title plan didn't coincide exactly with the boundaries on the ground. Also confirmed the area of ground which she had been told was included in the title was out with her title. And Miss Golightly refused to pay, basically saying, well, you haven't told me anything new, and you haven't sort of improved my position as a consequence of the work that you've done. So I'm not really interested in that. The argument about whether it was of use to her was irrelevant. What I was interested in is what, once again, issues associated with boundaries. And Miss Golightly explained to the judge in this case that her sale of her property had been prevented due to the boundary difference, lender refusing to lend against it, title described as unmarketable, and she maintained that she was entitled to compensation. So again, it just highlights the importance when acting on behalf of a seller to make sure that your client is satisfied as to what they own, and also that you're satisfied with the title that the seller is offering. Really interesting case, not for the debt action or anything else. It was just, the fact that she was trying to do the right thing, unable to do the right thing, and sued the providers of the report as a consequence. And the next case that I saw was a case involving Russell and Aitken, Falkirk and Alloa Limited against Allison. And this was defenders, it was alleged, had failed to inform their clients of the content of a property inquiry certificate. Has anyone seen this case? It was sent, they failed to inform them of the content of a property inquiry certificate sent to them before settlement, and that had they known about that certificate, they would have withdrawn from the transaction. Defenders said that the claim should be dismissed. The case was heard by a sheriff, and the facts were that the pursuers instructed solicitors to act for them in the purchase of a house at 6 Hillcrest Square, Falkirk. Missives concluded with a date of settlement 21st of December 2021. Missives incorporated clause 21 of the standard Scottish clauses at the time, obliging the sellers to exhibit a property inquiry certificate and entitling the pursuers to resile without penalty if it disclosed any matter which was materially prejudicial to the purchaser or the property. Shortly before settlement, the solicitors received a PEC from the seller's solicitors disclosing a PAC on the Greenfield site to the west of the property. The PEC wasn't sent to the clients, nor were they informed of the proposal, which they contended they only discovered or found out about in January 2022, when they learnt that an appeal had been lodged by a developer against the refusal of planning permission. Appeal successful, houses subsequently built. The buyers, the purchasers, contended that had they been aware of the proposal, they wouldn't have proceeded with the transaction. They now intended to move somewhere else and would incur loss in doing so in respect of conveyancing costs, capital expenditure incurred on the property prior to learning of the proposed damages and of the proposal, and damages for inconvenience and stress. Counsel for the defendants accepted the pursuers' averment that they wouldn't have purchased the property if they'd known the content of the PEC was a matter of proof. The pursuers offered only to prove that the defendants were required to inform them that the PEC disclosed information which may have been material to them. The presupposition was that defendants could somehow know that the proposal would be material to the pursuers, absent to a communication to that effect. So you have a really interesting claim. One of the things that was put before the court was, was this irrelevant, the fact that the PEC hadn't been disclosed? Was it irrelevant or not? And the court said that the test was a case called Hunter and Hanley 1955. In other words, the pursuers were saying that no solicitor of ordinary reasonable competence would have failed to make them aware of the housing proposal prior to settlement, thereby giving them a right to resile. That is not a claim which is irrelevant and necessarily bound to fail. It doesn't become so just because the pursuers didn't previously tell the defenders that such a housing proposal would be materially prejudicial to them. This case is a great example of a point that's frequently made, namely that you are obliged to advise a client of anything that's materially adverse to the interests of the client, whether in your retainer or engagement letter you've excluded or included advice on that topic. Now, again, the court did emphasise, looking at Hunter and Hanley, that there could be cases where something disclosed by the PEC is on the face of it so minor that a reasonably competent solicitor wouldn't be under an actionable duty to inform their client of it. So they said, for example, an application for permission to replace windows on a nearby listed building. But on the other hand, there may be cases where there could be no sensible dispute that the solicitor would be obliged to inform. For example, that permission had been granted for developing an open cast mine next to the subjects of sale. So again, just a really interesting case highlighting the duties and obligations that you owe to buyer clients. The court then looked at the issues of loss and of damage. And again, as far as that was concerned, I don't think the pursuers recovered all of their costs. It's not necessary for the pursuers to avert and prove the overall value of the property with and without the capital expenditure. These are simply matters which the sheriff, after proof, may wish to take into account in taking a broad and robust approach to quantification. So the issue of what damages the pursuer was entitled to wasn't resolved by the court at that stage. But again, an interesting case, just highlighting this point. If in doubt, report it to the buyer client. And then there was another case I was looking at last week. I don't know if you've seen this one, reported on 21st of November 2024. And it was a dispute involving a property in Aberfoyle, where there was a sort of, once again, a boundary dispute, where was the boundary running between two properties, and a claim for trespass and harassment in connection with the removal of a fence and the felling of a large Douglas fir. So a sort of traditional boundary dispute. And it was a case called Rose against Baston. Citation I'll just put in the chat box there. And it involved the removal of a boundary fence, with the pursuer seeking rectification of a title sheet, interdict, the restoration of a fence and damages. The defenders accepted that they'd entered the disputed portion, but said they were entitled to do so, as the land in question formed part of the land on their title sheet. Well, how often do we see that? And the case was heard in the outer house of the Court of Session, and the court had a look at the title. And the essence of the pursuer's claim, the court felt, was that the defender's registered title in the cadastral map erroneously included the disputed ground, which she had used and cultivated as garden since 1987. Counsel for the defendant submitted that there could be no inaccuracy in title, as the owner of the land had benefited from the keeper's Midas touch when he obtained title in 2009, with the effect of conferring title on the disputed portion to him. The lawyers for the pursuer submitted that the Midas touch was nothing to the point, since the pursuer was offering to prove that the keeper had the power to rectify the register immediately before the designated day. Defender's argument conflated what was conveyed in 86 with what was in 2009 a registered title, but the pursuer's position on averment was that the latter didn't conform to the former. Again, just highlighting the need to ensure that caution is exercised with regard to boundaries and boundary problems, and that as far as title sheets are concerned, again, caution needs to be exercised so that when a buyer inspects the property, they have a title sheet and can see how that sits with what they see when they inspect. So again, another really interesting case. If anyone wants copies of the case reports relating to either, I'm happy to provide that. And again, no one has entered any sort of points in the chat as yet. So I'd be really interested if anyone has any comments or any issues that they'd like to explore. But while we're doing that, there's something else that I want to talk about, and that's money laundering and AML. I'm doing some work at the moment where I'm providing case studies to firms and asking fee earners, what would you do in this situation? And I've got something that's really interesting at the moment, and I'll put this to attendees today. If I instructed you to act for me in connection with the purchase of a property from the Church of Scotland, and I advised you that the funds that I would be using to facilitate the purchase would be cryptocurrency, would you be prepared to act for me? And what about this? If I said to you that, if you asked me where did I get the funds that ultimately became cryptocurrency, and I said that I was trading on eBay or something of that nature, again, would you be happy to act? So I'm going to put that to the room and what people think. Number one, source of funds, cryptocurrency, happy to act. Charlotte is saying don't accept it. Anybody else? I know one firm in London that will accept transactions where funding is crypto-based. If you look at the National Crime Agency advice relating to cryptocurrency, they're saying way, way, way too dangerous. What about, David, if a client offered to pay you your fees in cryptocurrency? Would that be different? As a source of funds, I can well see why no one would touch it. Personally, I wouldn't accept it as a means of payment of fees either, to be honest with you. Okay. No, I agree, Charlotte. It's just too, there's enough risk out there without getting involved in that sort of thing, would be my view. Okay. On sources of funds, the client that's making fortunes via eBay sales or something of that nature, where are we with that? I was with a firm in West Yorkshire, and they had a client that was doing exactly, and when I talk about fortunes, I mean fortunes, averaging 40, £50,000 a month of eBay sales, and their compliance team were unhappy about acting. A, because this guy didn't have accounts. B, because he didn't provide any evidence that he was paying tax on his earnings. And so the firm again was taking a view. So I don't know what your view would be on that one, Charlotte. So the client that has income can prove where the income is coming from, but can't prove that he's paying tax on it. I think you've got to ask questions. You're not expected to be MI5, but you are expected to ask reasonable questions concerning sources of funds, etc. And if you don't get a satisfactory reply, then I think you're perfectly entitled to say it's not worth taking risk. Yeah. What about sources of funds if you've got a relative of your buyer client who's gifting, say, £50,000? Would you ask the third party for evidence as to where that £50,000 came from? Yeah, I would always ask, and again, I think it's important that your buyer client understands that you will ask. So in your retainer or engagement letter, hi, Carol, by the way, and Ian, and Diane, of course, I would be asking the client right at the start, if you're getting funds from a third party, we will be asking where those funds came from and would want proof of funds. And if unless proof of funds were provided, we wouldn't be willing to accept that as a source of funds. So, you're setting out your position right from the outset. Where a number of firms in England encounter problems is that they raise that as an issue when, uncle or aunt, the third party provider, is mentioned. And then it's, we need this. I think you need to deal with that right from the start. Next issue, what do you do about AML training for staff? Again, I'm doing a project on behalf of a firm that has over 400 members of staff. And what we did last week was an exercise in looking at all members of staff to say, do they need AML training or not? So let's just go through them. Receptionists don't actually handle transactions at all, but have client contact. Onboarding staff that again don't conduct the transaction but will onboard clients, verify ID, etc. Paralegals that are working on files supported by a line manager, qualified lawyer, or a head of department. So I'm saying all of these people need training with regard to anti-money laundering. And when we were discussing the receptionist, I said, well, hang on. The receptionist could get a telephone call from me saying, I want to deposit £20,000 in cash. Can I come into your office this afternoon with my suitcase to hand it over? You know, the receptionist that says no problem, or the receptionist that says anything other than no, you can't do that, I think could generate problems for us. So again, caution needs to be exercised. And with regard to support staff, if a member of staff is having client contact, I think it's important that they have basic AML training. So just to be clear, what we've said is there are three categories of training for staff. Basic AML training for all staff, doesn't matter who you are, basic level of training. Anyone undertaking transactional work, property related work, receives additional training. And then you've got private client, company commercial, conveyancing, commercial property teams receiving yet more training. And as far as that training is concerned, it is training on process, it is training on what are red flags, it is training on internal reporting procedures and processes. So there's a lot of work involved in that. As I say, you know, what I thought was a relatively simple exercise for this firm is turning into a nightmare. And one of the things that we're doing, looking at the requirements for AML training, is producing case studies and saying to people that are attending this training, you've got to complete the questions relating to those case studies so that we've got evidence that we can produce to professional bodies to confirm not only have we given or facilitated training, but we've also got data to record to what extent that training has got messages across. So it's an interesting one, isn't it? So, Carol, what do you do with regard to your AML training? And Diane, again, same sort of question. Ian, Charlotte, David, how do you deal with things at the moment? Would you say everyone in the firm needs training on money laundering? Or are you of the view that there are certain members of staff that aren't exposed to risk or aren't exposed to all risks, and therefore it's not necessary? Yeah, client contact or taking payments, they need training. So that's a fairly wide spectrum, isn't it, Charlotte? And Carol is saying, yeah, everyone does it. I think that's got to be right. But I have come across firms that are saying, well, no, you know, junior members of staff don't need it, only the fee earner. Yeah, exactly, Charlotte. Or, you know, you could have a situation where a client contacts a junior member of staff and, you know, the junior member of staff says, well, yeah, it's all right. You know, send £3,000 into our client account. Again, I was just looking at a decision of the Solicitors Disciplinary Tribunal in England, where, in essence, the firm had allowed a client to use a client account as a banking facility. So he'd been paying in dribs and drobs, £1,000 here, £3,000 there from time to time. And, you know, not for any particular transaction, but just on the basis that he would be buying a property at some point in the future. And again, you know, the professional body's attitude was, well, you know, that is exactly the sort of thing that we would view as a red flag. So, yeah, I'm glad to see that we've all got training on that, and every member of our team is aware of it. Next thing, which again was something that was put across my desk yesterday, revising fees. So I've instructed you to act in connection with the transaction. You've provided me with an estimate of fees, and the transaction proceeds, and it's complicated. There are boundary issues. There is an issue with regard to the need for a defective title insurance policy, etc. So more work is required than originally envisaged. Question number one, would you all tell me, if I was your client, that additional work was being undertaken, whether you were charging or not. Would you tell me there's an additional cost? Number two, if there was an additional cost, would you revise your fee estimate or your quotation? And how would you do it? This firm I was talking to yesterday was saying that they would just simply take a hit. Yeah, and I think that's the point, Charlotte. You've got to notify your client before you do the work. You've got to explain the work that needs to be done. And you've got to explain to the client the costs that could be incurred as a consequence. You can't simply tell the client at the end of the transaction that you've done additional work and therefore you're charging for it. There is case law that says you are entitled to revise conveyancing fees if there's an objectively valid reason for revision upwards. In other words, if something happens during the life of the transaction that you could not have envisaged when you first undertook the work. You can't charge extra for advice with regard to co-ownership, where you're acting for more than one party, on the basis that, you know, that this advice that you give relating to co-ownership would be advice that you'd normally provide to a conveyancing client. But other than that, you could charge. Yeah, Charlotte, that's fine. Fixed fee. Yeah, happy with that, Charlotte. Yeah, okay. And the next thing I had that I wanted to talk about is if you're acting on, and this involves online auctions. Anyone dealt with an online auction in Scotland? So rather than a face-to-face auction, an online auction. I think it's Wilson's auctioneers in Glasgow do online auctions, don't they, involving land? Don't know if you've seen them. Online auctions, anyone? And as I say, I've encountered a firm called Wilson's that do online auctions in Scotland and Northern Ireland, and Southern Ireland, to be honest with you. And again, the reason I mention this is I dealt with a matter in England recently where a firm of lawyers received instructions from family and friends that were funding an acquisition in connection with an online auction. So you had, I think it was 6 parties, all of whom were chipping in funds so that one of the parties could bid at an online auction. And the problem with this scenario is that the successful bidder realised, A, that the property that he'd successfully bid on was a bargain, a real bargain, and B, that he didn't need funding from everybody else. He could fund it himself, so that's what he did. And what you had then were the other aggrieved parties that thought they were sort of joint venturers in the transaction losing out. And lawyer is in the firing line on the basis that who was the lawyer acting for? Was he advising the bidder? Was the bidder properly nominated to bid? What were the interests of the other participants? Were they funders? Were they joint venturers? Just what was the position? So again, be careful with that. Make sure that if you're acting in connection with an online auction for a collective, that the status of the collective is agreed and understood. Carol, hi Carol. Carol's looked at this issue on costs. Yeah. You do have to think about client reaction. What about abortive costs, Carol, on a transaction that fails to proceed? What's your view on that? I know some firms that will just say, well, yeah, we'll take the hit. Others will charge. Some will charge a nominal fee. Others will charge whatever costs have been incurred relating to the transaction. What was the outcome of the auction one? It hasn't been resolved as yet, Gerald. Okay. But the lawyers currently, I think the funders are contemplating suing the funder that was the successful highest bidder. They're also potentially suing the solicitors who acted for the highest bidder on the basis that the solicitors were also acting on behalf of the funders, if I can call them that, Gerald. So I don't know what the outcome will be, but I can see how the solicitors could be in trouble. One, in not verifying the identity of the funders, because they were potentially clients, not ascertaining what their status was, not verifying identity, and not advising on the creation of some form of agreement, partnership agreement or whatever in connection with the process. So, Gerald, can I ask you a question? Have you acted on an online auction before? And Carol, you're charging a restricted fee for a board. Yeah, I think it's sensible, isn't it? I mean, if you don't charge, there's an argument that you're undervaluing the conveyancing service. If I'm of the view that, you've done a load of work for me and you haven't charged for it, being the sort of cynic that I am, I might be thinking, well, what's all this conveyancing process actually about? The individual, Ian. So with an online auction, you'll sometimes see the auction happening on a Friday evening. And some auctions, at the close of the online auction, if you're the highest bidder, you are contracted to purchase the property. Others, you're given the opportunity to proceed to missives. But it was the individual in that case, Ian, that made the highest bid. Yeah, it's obviously not that much of a deal in Scotland. It's getting to be more and more of a deal in England, to be honest with you. I'm getting more and more asked about online auctions, auction conditions, etc. And there are some pretty horrible auction conditions that can apply and that are stacked heavily against the successful buyer, and also are very heavily weighted in favour of the auction house. So, if you ever are involved in those transactions, do have a look very closely at the auction conditions, and also look at your retainer with regard to buyers. What are you going to do? Because some of these auction houses allow the auction conditions to alter during the auction, and some of the auctions are taking place, as I say, in the evenings or actual weekends, etc. Okay, anyone else got any burning questions? Any topics for next time? Do have a look at that book if you're interested. It's well worth a read, really interesting stuff. And as I said, I'm going to get Ian Mitchell to come along at a future forum. But anyone got any topics they'd like to discuss today, or anything you'd like to explore next time? In the meantime, what I'd like to do is, first of all, I'd like to thank Tom Bailey for attending today and explaining once more about his products, both the post product and data collection product, both of which are really interesting. To thank Stewart Title for once again sponsoring today's event and allowing me the opportunity to speak to you good folks. To you for your time today, because I appreciate how busy everyone is. A massive thank you to you. And we have another webinar in a month's time. We'll be looking at whatever topics you'd like to explore. Feel free to send me an email. I'll put my slide on there if I can, with my contact details. We are having a conference on the 9th of September now, 2025. We pushed it back on the basis that there were so many conferences early in the season, sort of Q1, Q2. So we've gone to September for our conference. Anyone interested in attending that, let me know. If you would like any speakers to come along and speak to you, again, let me know. Tom, I know that you're back on screen there. Thank you. Massive thank you to you. I'll put Tom's contact details back on slide there for anyone that's interested. And I think on that happy note, given, Tom, that my throat is just about running out, which is good news for some, but not for me, I'm going to finish at that. Massive thank you to Robert Kelly, John and Liz at Stewart Title. Massive thank you to you, Tom. Tom, are you still in foreign shores? Are you in Manchester at the moment, or where are we?
I'm in Lisbon, actually.
Hey, Lisbon, I tell you what, yes. I wonder why you were smiling. Yeah, exactly. Jolly good. Well, thanks so much for giving up your time today. Thanks, everyone else. Speak soon. Tom, love to keep in contact with you. Stay in touch. Thanks, everyone, and see you all next time. Thank you. Bye-bye. Bye-bye.